Stuart.
Yes. So, Tucker and Granada, this is behind tab 20. And put shortly, this was a payment by Granada Motorway Services of £122,000 to reduce the rent payable under a lease from the Minister of Transport. So it was altering the lease to provide for a lower rent. And the question was whether that was capital or revenue. And Lord Wilberforce gave the main speech. And if we just turn on to page 382, letter B, he says it's common in cases where the question, which raise the question whether a payment is to be treated as a revenue or capital payment for indicia to go in different ways. In the end, the courts can do little better than form an opinion which way the balance lies. There are a number of tests which have been stated in reported cases which are useful to apply, but we've warned more than once not to seek automatically to apply to one case words or formula which have been found useful in another case. That was in Changa. Nevertheless, reported cases are the best tools we have, even if they may sometimes be blunt instruments. I think that the key to the present case is to be found in these cases which have sought to identify an asset. In them, it seems reasonably logical to start with the assumption that money spent on the acquisition of the asset should be regarded as capital expenditure. Extensions from this are, first, to regard money spent on getting rid of a disadvantageous asset as capital expenditure, and secondly, to regard money spent on improving the asset or making it more advantageous as capital expenditure. In the latter type of case, it will have to be considered whether the expenditure has the result stated, or whether it should be regarded as expenditure on maintenance or upkeep, and some cases may pose difficult problems. That was the distinction I was referring to right at the beginning this morning between improvements and repairs.
Yes.
It is in this connection that so many discussions start with the well-known phrase of Viscount Cave in British Insulated, and then he quotes from what Viscount Cave said. Those words were regarded as having quasi-statutory force until, in a later case, it was revealed that they might cover in advance more of a revenue character. So Mr. Justice Rowlatt in Anglo-Persian Oil explained the phrase as meaning a benefit which endures in the way that fixed capital endures, not a benefit that endures in the sense that for a good number of years it relieves you of a revenue payment. It means a thing which endures in the way that fixed capital endures. It's not always an actual asset, but it endures in the way that getting rid of a lease or getting rid of onerous capital assets endures. So that's the kind of extension from what is the obvious case, which is where you're dealing with an actual asset. So here we obtain an indication that while the fact that the benefit obtained was enduring, in the sense that it might last for over 40 years, it's not sufficient to make the payment a capital payment. The payment to get rid of a lease might be so sufficient. What then if the payment is to get rid of a disadvantage in a lease? We obtain further guidance from Mallet. In that case, there were two payments, one to persuade the landlord under a mining lease to accept the surrender of it, so to free the lessee from possible liabilities, the other to persuade the landlord to modify a different lease. You may remember that, as we said, it was two leases, one where it was only part of the lease that they were dealing with. Of the latter, Lord Justice Sarvin used these words: it's a payment made for the purpose of modifying the conditions of an existing asset so as to make the resultant term more advantageous or less advantageous for the enduring benefit of the trade. These words admirably fit the present case, but we must beware of the formula trap. He was speaking there of a modification which involved the release of a parcel of land from the lease, something, in other words, within the classic case of a disposal of an asset. So he goes back. That's the kind of case, the core case. Nevertheless, we are asymptotically approaching the present case. Other instances are provided by cases concerned with petrol filling stations. The test they accepted and applied was whether a capital asset could be identified for which the relevant payment was made. I passed the other side of the narrow dividing line. Nearest to this line is IRC in Cannan, which we've already looked at, so I think we can probably pass over that. And he then says, under the quote, with due caution against using these words as if they were statutory, I adhere to them. The quote was from himself in IRC in Cannan. They were, of course, directed to excluding cases where no capital asset could be seen or identified, which was that case. I had not intended to narrow the conception of capital payments to the case of the acquisition of an asset. Clearly, expenditure on a capital asset may fall within the principle. Finally, I come to Anglo-Persian Oil and Dale, the sheet anchor of the appellant's argument. The payment there was in order to free the company for a long-term agency agreement which had become onerous to the company. Now, there may not be much commercial difference between a payment of this kind and a payment to get rid of an onerous lease, but since the courts have accepted and worked the identifiable asset test, the decision was no doubt right in law. The test may be to some extent arbitrary, but it provides a means which the courts can understand for distinguishing capital and income expenditure, and I think it would be wise to maintain it. And then he says, my lords, I should refrain from analysing further examples of cases either way. The recent decisions of Pitt and Castle and ECC Quarries fully support the identifiable asset test. So it seems to have been, I think the assumption is he was approving it, since he relied on it in a sense. They fully support the identifiable asset test. So it remains to decide the present case. For myself, I cannot doubt where it lies. It is a case for once and for all expenditure on a capital asset designed to make it more advantageous. It is true that the lease was non-assignable, so it had no balance sheet value before or after the modification, but it was nonetheless an asset and a valuable one for the appellant's trade. And if an asset was a capital asset, it appears to me to be impossible to divorce the payment from the lease and to regard it as simply a payment intended to increase the appellant's share of the profits. That it may have done, but the parties chose to do it through the medium of a lease, just as in the petrol filling station's case, the object of increasing gallonage sales was effected through a lease. Nor, in my opinion, can the payment be regarded as a payment of rent. That would be to confuse the measure or basis of calculation of the payment with its nature. I agree, therefore, with both courts below in regarding the payment as a capital nature. I add one word as to the decision of the Special Commissioners, who took the opposite view. It seems to me clear that to reverse their decision involves no interference with any finding of fact within their exclusive competence. The findings submitted by them for the court, clearly one of fact, has been accepted throughout. It is only on the consequence of that finding that the courts are taking a different view. That involves a pure question of law on the decided cases. I would dismiss the appeal. Lord Salmon dissented, in fact, in this case. That was because he took a different view.
Mr. Ewart, sorry to interrupt.
Yeah.
Before you leave the speech of Lord Wilberforce, can I just ask you a couple of questions?
Yes.
On that last page, 688 of the report.
Yeah.
The first question is, he, as we've seen in other authorities, treats the question of whether it's revenue or capital expenditure as a pure question of law. So is it your submission that before we can reverse the decision of the tribunal below, in our case, we don't have to identify any misdirection of approach, for example? We're simply entitled to form our own view as to whether this is or is not capital expenditure.
On the basis of the primary facts found by the tribunal.
Of course.
That's correct. In fact, I will be saying that there were misdirections and errors, but that's not necessary.
I see.
Yes.
That's helpful, thank you. And then my second question is in relation to the status of Mr. Justice Brightman's decision in ECC Quarries. And of course, I note what Lord Wilberforce says about that, and I understand your submission about that. But is it your submission that ECC Quarries is binding on this court, or simply that it's owed some respect because it's been approved by Lord Wilberforce?
It reflects, yes, it's not formally binding, of course, on this court.
No.
I don't think, we haven't found any case where it's been formally approved in a sense that would make it binding on you yet. I don't know that. Yes. But it's certainly, nobody has ever questioned it as being in any way incorrect. And indeed, clearly Lord Wilberforce didn't question it in this case.
The only difficulty may be that, as Lord Wilberforce, I think himself says, so much turns on the individual circumstances, and cases do fall on either side of the line. I mean, some people might find Cannan surprising, but there it is. The House of Lords decided it the way they did. Yeah. And what I'm really struggling for, and no doubt you will help us later on this afternoon in your submissions about the present appeal, is how we approach something where there isn't an identifiable asset that's being paid for, but it's, for example, legal advice and other professional advice, other professional services along the way, with that in mind, but that's not actually what you're buying, because it might be said what you're buying, what you get when you pay a law firm is probably a document headed legal advice.
Well, it might be, or it might be a document headed lease,
Yes.
and the transaction may be a lease.
Yes.
I mean, my starting point is a general principle which
Yes.
Lord Wilberforce set out on page 686,
Yes.
letter D. So it is, and in the present case, we identify the capital asset as being what was disposed of. So it is, we would say this is money spent on getting rid of a disadvantageous asset, putting it colloquially.
Yes, can I press you on that? And what precisely is the capital asset in this case?
Well, in purely formal legal terms, it was the company that was sold in the end. The company that was sold.
Sorry, several companies were sold in the end.
Well,
And neither of them was the taxpayer company.
no, the company was sold by Oxio. Oxio sold the company.
Well, did it? It was the. It may have been called the vendor. Was it there? I mean, did it undertake to procure the disposal of shares and subsidiaries, or how exactly?
The business was, as I understand, part of the business was hired down to a subsidiary.
Yes, that's what I thought.
And the subsidiary was sold to the.
This is quite a long way down the line, and you say the initial decision was taken to dispose of an onerous asset. Now, what asset?
Well, commercially, the onerous asset was the business of Oxio, because when we look at the things of fact, we'll see that was draining cash from Centrica. They were continually having to put money in because the business was, operating badly, and that was what they were disposing of. Commercially, they were disposing of the business.
But I thought the original idea was to dispose of shares.
Well, they would have got rid of the business. I think the original idea was they would get rid of the business by selling Oxio.
By selling Oxio.
Yeah, that was the company that owned the business at that time. The problem I think you see, which arose, was the purchaser, as often happens with sales, the purchaser doesn't want the original company because it has a history, it may have liabilities, it may have all sorts of problems. What it wants is the business. So there's two ways they can do that. They can either buy the business, that sometimes happens, they buy the business from the company, perhaps into a new company that they formed, that may be the case, or the vendor carries out a reconstruction to put the business into a clean company, which they can then sell. But this is all part of the sale, and the reason why you might do one way or another will depend on commercial considerations, tax perhaps, regulatory, other reasons. But at the heart of all of this, what they were trying to get rid of, Centrica, was the Oxio business that was hemorrhaging money at that point.
Well, I mean, that's a phrase that makes a lot of sense to an investor or to a businessman. But
that's what the way Centrica looked at it.
Yes, but I mean, the buyer has to analyse it in terms of assets. And I mean, you're inviting us to, I think, to take the line that the facts of this case come within the principles stated in Tucker and Granada about disposal of an onerous asset.
Yeah.
I mean, can you show us any case where there has been an asset of a similarly, what should I say, soft-edged or amorphous type, which one can grasp conceptually, perhaps, in business terms? One can't really, but there are various different ways, legally different ways in which that objective could be achieved.
Yes, I don't know about that. I would suggest that there's no problem in a business. Yeah. I think would be a capital. If you sold your business, that is a capital transaction. I don't think there couldn't be any doubt about that.
Yes.
You'd be selling assets and goodwill and whatever, but it would be a capital asset transaction. So if they had sold, if Centrica or COHL had actually owned the business themselves and had sold it, there's no doubt that would be a capital transaction. And I would submit if they had hired it down to a company and sold it, there'd be no doubt that was a capital transaction.
Yes, one can imagine a sale and purchase agreement between Oxio as vendor and an outside purchaser saying that effectively, however, the lawyers advise the transaction has to be structured, Oxio covenants that it will procure such and such an end result, or something like that.
Well, I think that, I don't think that was formalised into an agreement, but I think that would be the position, the negotiating position between Centrica or probably actually Deutsche Bank, who were acting on their behalf to negotiate, and the purchaser, and no doubt the purchaser, Centrica, might say, we'd like to sell you Oxio, the purchaser might say, "Well, I'm not sure about that. I like the business, but I don't want the company."
And so the purchaser will probably then draft an agreement of the type it would be happy to sign up to and sends it over, and vendor says, "We can live with this," and then we have a deal.
Yes.
Like that.
Well, you could guess that the business, those who were negotiating it, might say, "Okay, we'll get another company and drop it into it and sell you that."
That's
Now, how precisely you do that, of course, is a matter for the lawyers to.
That's machinery, and that's why you need your lawyers. You send it off to them and say, "This is our commercial object. These are our terms agreed at an all-night bargaining session. Please put it into legal form."
Yes, and if it was a UK company, this is a Dutch company. If it was a UK company, of course, you'd be looking at all the reorganisation, reconstruction provisions to make sure that you did it in a way that didn't trigger a tax charge. But the advice in this case was from a Dutch lawyers about that. Obviously, there's no doubt similar considerations applied. But my broad point is, however the mechanics ended up in the end, what they were aiming to do was to dispose of a capital asset.
Well, I suppose my question really is, at how high a level of generality can you identify a capital asset for this purpose?
Yes.
And I think you're saying at a very high level.
Well,
or at least at a commercially high level.
Yes. Although the fact is that the actual, however it was disposed of, it was a capital disposal.
Well, that's rather the question, isn't it?
Well, whether it was
I see. Yes.
Yes, it was disposed. But if they disposed of Oxio, that was a capital disposal.
I
If
see.
they disposed of a new company, it was a capital disposal. It doesn't change the nature of the disposal at all. They're all capital disposals. But what I would say is that the way the group was looking at it was not that they would be selling the company; they were wanting to get rid of the business, one way or another. Now, the simplest way would be to sell Oxio, obviously, because that would involve any steps. You could sell Oxio.
That naturally enough was the starting point.
And if a purchaser would be prepared to do that, then I'm sure that's what they would have done. Yeah. But I think we'll see. I'll come to the findings of fact later.
Sorry, in the sense I was jumping ahead of it.
Yeah.
I mean, anyway, thank you.
Don't worry, but yes, my starting point is that the principle is I think what Lord Wilberforce refers to as the identifiable asset test. That if you can identify a capital asset that's being sold or acquired, then that really answers the question. That's a capital transaction. And expenditure on that. Now, you might have to ask the question, what's expenditure on the disposal? But expenditure on that would be capital. The difficult cases arise, I think, as they've said, where you don't have an identifiable asset of that kind. That's why Cannan, ECC quarries even perhaps, although maybe it's easier, and Atherton, where there was no identifiable asset, and all the cases, the petrol tie cases without the leases, where there was an advantage obtained by a payment, but it wasn't an asset in identifiable form.
Well, if you're looking at an asset in the broader sense which you advocate, why was the nucleus for the pension fund in Helsby, in Atherton, not an asset?
Well, it's an asset in the sense it was,
yes.
There were rights.
It was set up for the enduring benefit of the business,
Yes.
for the benefit of employees.
Yeah.
There would have been a trustee, there would have been...
It certainly wasn't looked at as... Yeah, but what I mean by identifiable assets is something that you would identify as being an asset that you buy and sell, like a lease, like a business.
It doesn't have to be tangible, obviously.
No, it can be, of course. Yeah, it doesn't have to be a tangible asset, it can be intangible, but an asset. Whereas I think the way that that case was looked at was that they didn't acquire anything that they could sort of sell or anything like that. They simply got an advantage because there was a pension scheme now for their employees.
I mean, on the face of it, absent a surplus, the rights would have accrued to the employees, not to the company making the payment.
Yes.
Yes.
That's right.
Yeah, that's right.
Yeah.
Yeah. So they didn't acquire a straightforward asset. And that was why the case was went different ways at different stages, I think. But the point I'm making about this is that the core of this is that there is what Lord Wilberforce talks about, the identifiable asset test. So you start with that. Can you identify an asset, that's a capital asset that's being disposed of or acquired or is being improved? And if that's the case, then the expenditure on that acquisition or disposal or improvement is capital. And from that's why he said, having discussed that, why he said that we were asymptotically approaching the present case, because it wasn't directly. I mean, they were approaching it, although I think asymptotically means you never actually.
I was going to ask you what it meant.
It's a mathematical term. It means a line that approaches a curve but never actually reaches it within a finite distance. So it's not quite appropriate, because I think he intended to reach at some point, but that's what it meant. So he said he's kind of circling the point at the moment. Hasn't quite reached it for this case, because of course in this case they certainly weren't disposing of or acquiring an asset. But I think what he decided was that they were improving the asset, essentially. So then, as Lord Salmon just entered, if we then look at Lord Edmund Davis, this is on page 3, he starts on page 386, but if we just pick it up at 387, on 386 he says he agrees with everything said by Lord Wilberforce, but he has a footnote, because they are departing from the decision of the special commissioners, and he felt it was right that they should explain why. And then you will see he sets out, in the paragraph just above letter D, he says it's common ground the payment of 122,000 made by the appellants of disbursement wholly and exclusively expended for the purpose of the trade of the appellants with the meaning of section 130A. And that's the only question, is whether it fell within the wording of paragraph F, thereof, as any capital withdrawn from any sum employed. I just actually to note that, as he's recording the fact that this is a trading expense that would qualify, but that doesn't answer the question as to whether it's capital. I just make that point in the context of the idea that whether it's an expense of management somehow determines the question. And we would say, in the same way as trading expenses can be capital or not, so can expenses of management. They're both very analogous kinds of expenses. And then he quotes various parts, you'll see from the Special Commissioner's decision below, underlying purpose in the various places where it appears. And he says, in the paragraph after that, each of these propositions, Special Commissioner cited authorities, but he says that whether the expenditure was a capital or revenue nature are questions of law and as such freely appealable. That's the end of that paragraph. And then he says, under the quote, he says, considering how they should be answered, the proper starting point is surely that it has throughout been undisputed that the 3 leases represented capital assets of the appellant's trade. Next, to be borne in mind that while guidelines are provided by the said occasion, not be thought that particular phrases employed in them will unerringly lead to the right conclusion. And then he goes on in the next paragraph, said Lord Wilberforce has examined the cases and discussed them. He won't go over them again, but he confines him. I confine myself to commenting on the great weight, this is the letter H, they manifestly attach to the purpose for which the appellants paid the landlord 122,000. Indeed, this purpose element featured no less than 3 times in the reasons given by the Special Commissioners, as they did. And then he quotes Sir David Cairns, who says, so far as the Special Commissioners decided the case on the ground that the payment was in their view not made with a view to bringing into existence some asset or advantage, the enduring benefit of the trade, they misdirected themselves. The question they ought to have asked was whether the payment did bring some asset or advantage into existence. Was it an enduring asset or advantage, enduring the same way that fixed capital endures? If I may respectfully say so, these words commend themselves to me, and they conform to the warning given by Lord Radcliffe in Changa about the undesirability of determining the nature of payment by the motive or object of the payer. To apply that as a sole or principal test is unsatisfactory, for as the respondents have rightly submitted, the purpose of any payment will generally be to improve the company's trading profits, even if the purchase is an obvious capital asset. This could lead to the conclusion, contrary to many long-standing decisions in the field, the purchase of any asset must be regarded as involving revenue expenditure if it be made in order to reduce recurrent expenditure charged against profits. Although I'm persuaded to the view that the Special Commissioners relied excessively, if not indeed exclusively, upon the purpose test, rather than considering the matter in accordance with the established principles relating to an enduring, non-recurrent alteration or acquisition of an admitted capital asset, and not overlooking that, in the words of my noble learned friend Lord Wilberforce and Cannan, the disposition of a source of liability will be equivalent to the acquisition of a source of profit, which may be relevant to the present case. By doing so, they misdirected themselves in law, and your lordships are free to depart from their findings. And you dismiss the appeal.
Could it be said that that passage from Sir David Cairns, which is approved by Lord Edmund Davis, if anything, goes against you? Because could it be said that what you're inviting us to do is precisely to fall into the error of confusing what is it that the payment is for with a different question, which is what is the purpose or motivation? Because I understand your submission that ultimately, from a commercial point of view, what the taxpayer company here was trying to get was to rid itself of this onerous business.
Yes.
Right, I understand that's its purpose and that's its motivation. But why is that what the payment for the services from PricewaterhouseCoopers is getting?
Well, when we come to look, I'm sorry, when we look at the findings of fact,
Yes.
I think you will see that what that expenditure was on were all services, if you like, work that went to disposing of the capital asset, disposing of the business.
All right.
So they were all for that. The point that's being made here is it doesn't matter why you're trying to get rid of the business. You may be trying to get rid of the business to improve your profits,
Yes.
or remove losses, which is pretty much what they were doing in this case.
All right.
But that doesn't make it a revenue item. I think that was the point.
Thank you.
But there is some, in some of the decisions of the First Tier Tribunal and Upper Tribunal, there's some sort of suggestion that you look beyond the disposal to, for instance, the repayment of the loans. Now, obviously, that would be an effect of disposing of the asset, that they could repay the loans to the investment company. But that's confusing. Perhaps that's this confusion, the purpose with what the payments were for directly. They were for disposing of the asset. The purpose, a purpose of them might have been to enable the loans to be repaid, but that's not relevant in the circumstances.
On that thesis, it's a sort of immediacy test. It is a sort of purpose test, but you look at the immediate purpose, not the remoter purpose.
Yes. And you don't, but it's also, I would suggest, an objective test. So it's not a purpose test in the sense of what was in someone's mind, subjective purpose. It's highly objective. You're looking at what the payment was made for, not why they made it, not what their motivation was or their purpose.
I mean,
Maybe why it's a question of law.
Maybe it's a slightly unreal point in the sense that if you pay to get legal advice on how to get planning permission for something, it's a bit hard to see how your subjective purpose can differ from your objective one.
In that case, perhaps, but in other cases, it may be said, well, we paid this money to get rid of this asset, but our real purpose of doing that was the knock-on effects of it. And we know that there are lots of cases where it is a subjective purpose test. You end up with endless evidence from taxpayers as to what they had in their minds and why they did something. But I would submit this is not such a test. This is a purely objective test, looking at what the payment was and what it was paid for, and that's why the courts can determine it. They're not bound by what the special commissioners of the First Tier Tribunal said. Can I then take you to Lord Fraser? And perhaps if you could just pick it up and just read the paragraph that begins on page 390 above letter E, and then the following paragraph, which begins, I cannot accept that argument. can I then take you, that's all I had on Tucker. Can I then take you briefly to Beecham and Woolworths, which is behind tab 22. What happened in this case was the company borrowed in Swiss francs. It converted the Swiss francs to sterling and used it in its business. When it had to repay the loan, it then had to buy Swiss francs again to repay the loan. It made an exchange loss on that, and it claimed that as a revenue deduction. Now, the Special Commissioners held it was revenue, and that was reversed by Mr. Justice Hoffman. And if we just look at what Mr. Justice Hoffman said about that, at page 437, the bottom paragraph at letter G on, this is tab 22.
Sorry, could you repeat the page again?
Yeah, 437 in the bundle.
Yep.
And it's the final paragraph on that page. How did the Special Commissioners arrive at the conclusion that the loans were not capital? They attached great importance to the evidence of the company's finance director, who said the purpose of the loans was to tide the company over a temporary shortage of cash. The company considered various options, from making a rights issue to asking its bankers for increased overdraft facilities, and in the end decided to deal with the problem by raising the Swiss loans. It went abroad for the loans, partly because the rate of interest was more favourable and partly because it was then controlled by a US corporation. And there was exchange control issues. The loans were for 5 years because the Bank of England would not allow borrowing for this purpose to be paid within a shorter period. But, said the Commissioners, and this is a matter to which they attach great significance, the company was not seeking to add permanently to its capital structure, it was dealing with a short-term problem of cash shortage. It seems to me that attaching importance to what the company was seeking to do rather than to what it actually did, the Commissioners misdirected themselves. The fact that the object of the borrowings was to deal with a temporary shortage of cash is irrelevant if the solution actually adopted was to make an addition to the company's liquid resources sufficiently permanent to be regarded as an accretion to its capital. The rights issue contemplated as one solution would undoubtedly have fallen within this category, and I think a 5-year loan would do so also. The Commissioners seem to have discounted the effect of the 5-year term on the ground that the Bank of England insisted on this period. Again, it seems to me irrelevant that the company borrowed for 5 years because for one reason or another it was not possible or convenient to obtain accommodation for a shorter period. What matters is what the company actually did. In cases where there is no fixed term for repayment or where the term is of a borderline nature, the use to which the money was put may throw some light on whether or not it's an accretion of capital. But then he says, after citing some cases at the bottom of that page, at H, but this is not a doubtful case. The terms of the loan, in my judgment, are sufficient to make it clear that they constitute additions to the capital employed by the company. It doesn't matter whether they were intended to be employed in the making of payment of revenue or capital nature. In this case, evidence on that question will help because it's clear from the evidence for the Commissioners and the documents to which they've referred that the money was not intended to be used and was not actually used specifically for purposes of one character or another. It was simply an addition to the company's general funds. It follows that there are no relevant factors pointing to the borrowing being a revenue receipt. And then he deals with BP and Australia. Now, I think as my Lord indicated, the Court of Appeal reversed that decision on the basis that there was a question of fact from the Commissioners. That itself was then reversed by the House of Lords. Lord Templeman gave the only substantive judgment, and he actually considered at page 450, he said in the middle of the page, the weight of authority supports the view that the question whether the transaction in the present case was a revenue or capital nature is a question of law to be determined in the light of the facts found by the Commissioners, and that a trader who borrows 100 million Swiss francs for a fixed period of 5 years thereby enlarges the capital employed in the trade. So he's really decided the case in one paragraph, and then he reviews all the authorities on question of law and concludes at page 452 at the top, on principle, in the light of the judicial pronouncements which I have cited, the question involved in the present case is one of law and was rightly so dealt with by Mr. Justice Hoffman, who held the Commissioners had misdirected themselves. And then he goes on to deal with a number of the cases on capital. You'll see some which are familiar. And he then concludes at page 457. Let us see. After no more than 2 days of representing judgment, Mr. Justice Hoffman refers to all the relevant authorities and arguments and succinctly and correctly reversed the special commissioners, saying, and then he quotes the quote we've already read, in the Court of Appeal, Lord Justice Norris, with whose judgment the other members of the court agreed, rightly accepted the basic principle in regard to loans as a means of fluctuating temporary accommodation, there to be regarded as revenue transactions and not creations of capital. And Lord Justice Norris accepted the argument of Mr. Park based on strict. But Lord Templeman said, the taxpayer's trade was furthered over a 5-year period by an increase of capital during that period, not by fluctuating in temporary accommodation. The taxpayer undoubtedly made a loss of 11.4 million, but that loss was a loss in connection with a capital transaction. Unfortunately, capital gains tax legislation doesn't apply to currency exchange profits, etc. at that time. So there's 2 points you can get from this case. One is absolute final confirmation that this is a question of law, as is evidenced by the fact that the Court of Appeal thought it was a question of fact and they were reversed. And secondly, the distinction that Mr. Justice Hoffman, as approved by the House of Lords, drew between what the company was seeking to do and what it actually did. This is going back to the direct and the indirect.
Is it of some interest to note that top of 438, Mr. Justice Hoffman did mention 2 alternative ways of achieving the same result, which also would have been on capital account. There's a certain, perhaps slight resonance with the question I was putting to you.
Yes, exactly.
About alternative ways of achieving a particular business objective.
Yes.
Well, perhaps all it shows is that if there are a choice of methods, well, they may or may not be capital. It just depends what you do, doesn't it? Yes.
Yes.
Although in this particular case, the alternative C canvas would also have come to the same result, that it was a capital transaction.
Yes.
Yeah.
I could see if there were a number of options that were being canvassed, some of which wouldn't be a capital transaction, some would. You might have an interesting question.
And unlike the present case, you don't start, or at least as you would say, you don't start here with an identifiable asset of any particular type. It's more a particular problem, which is the shortage of cash and how to remedy it.
Yes, but the way they decided to remedy it was to sell,
yes,
to dispose of the business. Yes, one way or another. Yeah. The final case, I think I can deal with that quite shortly, is Wharf. It's actually at the end of Authorities Bundle 2, because I think it's regarded as a foreign case, because it's a decision of the Privy Council. Lord Hoffman, by now Lord Hoffman. It's tab 33 in Bundle 2. And the question here was whether interest paid on particular loans was revenue, its interest was revenue or capital. And the main reason, actually, that we're citing was 2 reasons. One, it again confirms it's a question of law, but also Lord Hoffman made clear what the position was in relation to in-house, if you like, employees engaged on capital transactions. And I think you'll find that if we look at, the opening few paragraphs set out the facts. It's not really particularly important, but the company obtained purchase money for purchasing a particular asset by borrowing from various banks and financial institutions. Loans are for short periods. And the question was whether it was to deduct the interest payments which had incurred on these loans. And if we look at page 779, at the bottom, just above letter H, Mr. Gardner QC made no point in the tramway licence fee, but did advance several other arguments against the conclusion that the interest payments were expenses of a capital nature. First, he said that interest was by definition a revenue payment and could not be anything else. The Lordships think this confuses the position of payer and recipient. It is true that in the hands of the recipient, interest will be either the earnings of capital advance or in some cases additional income derived from trading in money. In either case, it will have the character of income. From the point of view of the payer, however, a payment of interest may be a capital or revenue expense, depending upon the purpose for which it was paid. The fact that it is income in the hands of the recipient and a recurring and periodic payment does not necessarily mean it must be a revenue expense. Wages and rent are income in the hands of the recipients, periodic payments in return for services or the use of land or chattels, respectively. But whether such payments are of a capital or revenue nature depends on their purpose. The wages of an electrician employed in the construction of a building by an owner who intends to retain the building as a capital investment are part of its capital cost. So that would be if you employ people whose task is to construct or build a capital asset, then their wages are part of the capital cost of the building. The wages of the same electrician employed by a construction company or by the building owner in maintaining the building when it's completed are revenue expenses. Now, the reason the wages of the electrician employed by the construction company would be revenue in the hands, it would be because the construction company would be carrying on a trade of constructing the building. The construction company is being engaged by the owner to build the building. So their expenses would be revenue deductions in the trading calculation. But the wages of the electrician employed by the owner to build the capital in building is the capital. And similarly, if you employ someone to maintain the building, that's a revenue expense. And then 2 paragraphs on, he said, Mr. Gardner said it was not legitimate to examine the purpose for which the money was borrowed in order to ascertain whether the interest paid in consideration of borrowing had been a capital or revenue purpose. Their Lordships agree with Vice President Lytton that, on the contrary, there is no other way in which the nature of the interest payment can be discovered. The immediate consideration for each payment of interest is, of course, the use of the money during the period in respect of which the interest has been paid. But since money has no more than a medium of exchange, which may be expended for other capital or revenue purposes, the question can be answered only by ascertaining the purpose for which the loan was required during the relevant period. And then Mr. Gardner protested that this was contrary to the decision of the House of Lords in Woolworths. Unfortunately, we had Lord Hoffman who explained the following page why that was correct. On that page also, he says that below the quote, he says that it's directed to a different question, namely whether the sum borrowed constitutes an addition to the company's capital or is a revenue receipt. So it was a principal amount there. In other words, it looks at the nature of the loan in the hands of the recipient rather than the question of whether a payment of interest is a capital revenue expense. It's unusual for a loan of money to constitute a revenue receipt, but this can be the case if borrowing money is part of the ordinary day-to-day incidents of carrying on the business, which may be the case in businesses of banking, finance, or otherwise dealing in money. Ordinarily, however, a loan to a trading company, whatever the purpose which is intended to be used, will be in addition to that company's capital. Mr. Gardner did submit the shortness of the successive periods in this case were enough to make them revenue receipts, but the Lordships did not agree. The borrowing did not form part of the company's trading activities. While it or a replacement loan remained in place, it was an addition to the wharf's capital. Thus, while the question of whether money is intended to be used for a capital or revenue purpose is inconclusive as to whether its receipt is a revenue receipt or an addition to the company's capital, the purpose of the loan during the period over which the interest payment was made is critical to whether it, that is, the interest, counts as a capital or revenue expense. In the present case, during the whole of the 2 years in question, the loan was clearly being applied for the purpose of acquiring and creating capital asset rather than holding it as an income-producing investment. It follows that the interest was being expended for a capital purpose. And then they go on to deal with the accounting evidence. It's not relevant. I'm partly drawing attention to that case because it is stated at some point, I think in the First Tier Tribunal's decision, that if this had been done by the company's own employees in-house, then that would have been revenue. And in my submission, that wouldn't be correct. If they had put together a team to do the heavy lifting, as it's described, in-house, and then, as Lord Hoffman says, the wages that they paid them for that period when they were doing that project would be capital, not revenue. They're not revenue simply because they're wages, the point he's making. So it's not correct to say there would be a distinction necessarily between in-house work and where you subcontracted, as they did in this case, to Deutsche Bank.
I sort of see the logic of that in theory. It sounds a little unreal, but you can tell me I'm wrong. So you're a company that has an in-house lawyer and an in-house finance director, and they think about, I suppose they think about the implementation of an acquisition. The company has to, can't just treat its wages as deductible. It has to split them, apportion them.
Can we look at what we're talking about here is them actually carrying out the kind of work that Deutsche Bank carried out in this case? And if they had formed a team in-house to do it, which Deutsche Bank had a team externally which did it, I would say yes, it would be capital, because if they were engaged in finding purchasers, negotiating with all the stuff. I'm just going to turn to that now. What Deutsche Bank did, then that would be capital. Now, of course, there may be some cases where the employee is only doing a tiny bit of work, and you wouldn't necessarily want to do that. But in principle, that's right, and that does happen in real life. There are people who are on teams who are on capital projects, and in fact, I think it's right to say that their wages are often capitalised in the accounts of the company. It happens in IP kind of contexts where they're developing, a capital item, some kind of intellectual property. Can I then turn to the findings of fact, because I think it's important we look at those. And it's in tab 8, the First Tier Tribunal decision. We'd say it's important first to look at what the position was when all of this started up. And if we turn to paragraph 21 of the First Tier Tribunal decision, and if you just read 21 to 24, you will see this is what the position was at the start, in July 2009. This was more than an informal decision to seek a sale. This was very much a formal decision, which had the connotation that the sale was highly probable. You'll see by putting it in the accounts in that way, and it was also publicised. There's a number of articles in the specialist press about the fact that they were selling. And just on the point of how the company looked at it, if you just look at paragraph 19 on the page before, particularly the last two sentences. Strategic decisions of this nature will be taken at the level of the PLC board. Such strategic decisions would generally relate to businesses rather than the specific legal entities which might carry on those businesses. Unsurprising, perhaps, that they would be looking at it from the point of view of commercially the businesses. So, if we then move on to what the the parties were engaged to do and what they did. Deutsche Bank, if we turn on to paragraph 63, they record the engagement letter sent to Centrica for the intention of Nick Lough, who's the group finance director, and there's the three elements of the engagement, and the services you can see to be provided. So it is, in general terms, stated at the bottom of the page, financial advice and assistance in connection with the transactions. The transactions are the various disposals. Okay? It's defined as, which may include, if appropriate, advice, assistance related to defining objectives, performing valuation analysis, structuring, negotiating, planning, and managing the process of the transaction. And then you can see specifically what Deutsche Bank agreed to do. And so you can see the list up to K. They're all in relation to, directly in relation to the transaction.
I mean, if you just get back to 63, where we see Centrica has engaged Deutsche Bank as, there, A and B both say things that may lead to a possible transaction. Does that matter?
So
if you look, say, at A, it's exclusive financial advisor in relation to the strategic alternatives that may lead to a possible transaction.
Yes. Well, of course, there's always a possibility that there won't be a transaction. I think that's recognised. And of course, maybe there's some importance in that, because the fee, the Deutsche Bank fee, was conditional on there being a transaction. So it may be that Centrica just wanted to make it clear that there might not be. They're not guaranteeing there will be a transaction. So the fee was, paragraph 66, you can see, was payable at the time of completion. But I think more important is to look at more specifically what they were agreeing to do, because I think that gives you the idea of what it is that they were engaged to do. And of course, you could say in a sale transaction that a lot of what the agent is doing could be regarded as advice, in the sense that the seller, of course, has the final decision what to do. So they might be saying, we've got all these purchasers, we might suggest that you accept X or Y. But what they're doing here is everything is in relation to the transaction, getting the transaction over the line, getting it done. And indeed, that's what Mr. McCord said at paragraph 68. Just as when passing in 67, there was a kind of provision you see often in estate agents' contracts, which is that if Centrica terminated the engagement and then, without cause, and then completed a transaction within 12 months, then Deutsche still got their fee. 68, Mr. McCord explained that this kind of fee structure was typical in a sale transaction, was intended to incentivise the investment bank to get the best deal they could for the client and get it over the line. So a very high proportion of M&A transactions failed off at the last minute. If the investment bank did not get paid unless the transaction was completed, it was obviously in their interest to try and make sure the deal went ahead. Although the payment was made only on completion, the payment was compensation for all the work put into the transaction by a team of people from juniors to very senior investment bankers, in this case over a period of 2 years. He then said, sometimes if the transaction didn't proceed, Centrica would pay some of the fees or some of them if they thought the advice was useful, or they might award it the next mandate. But anyway, that was extra contractual, if you like. The fee was payment for the work done, although conditional completion was to be contrasted with the incentivisation fee, which is a true incentive payment made at Centrica's discretion, in this case €1 million. And then 71, an important part of Deutsche Bank's role was to evaluate the options available in relation to HMRC. The strategic decision to divest had already been taken, But the options as to how to achieve this were wider than in normal transactions because of the diversity of the businesses within the Oxio subgroup and the problems which emerged in the finances and management of the main customer business. It's not clear what appetite potential purchasers in the market might have for the different elements of the business. That was even possible the business would prove unsellable and have to be closed down. Of course, that's we would say the fact that the sale might go through, or they wouldn't sell at any cost or whatever, is irrelevant to this question of whether.
And just suppose
current expenditure
that the company had never decided to try to sell, but had simply asked Deutsche Bank to deal with shutting the company down. What would the position have been then?
Well, I suppose that still, I mean, if what they were incurring the expenditure on was disposing of the asset in the sense of getting rid of it, could be capital as well. Depends exactly what it was they were doing. Liquidating it, you mean?
Yes.
Yes. Sounds rather like a capital transaction. And then they say another major part of Deutsche Bank's engagement was to identify possible buyers and to evaluate the level of interest they might have in the different parts of Oxio's business. In June 2009, there was a document for Project Erasmus, which considered the buying universe of energy companies. So this was all, I would submit, exactly what you'd expect in a sales process. That you would look at who the buyers are, you'd assess them.
So obviously you emphasise second line of 71, the strategic decision to divest had already been taken. So
yes.
This is the working out of that strategic decision.
Exactly. That reflects 21 to 24. I think what we've seen already. I think that's why they were accounting for it in that way, etc. Because the decision had been taken. That's right. Then Deutsche Bank produced a paper on key work streams and timelines. This was on the sale transaction, who does what and when, etc. And then they set out what the next phase was, reviewing Oxio's business plan, doing a detailed process of work plan, making an evaluation assessment, etc. Now these are all, clearly the work here is more complicated than you might have in another kind of disposal. If you're selling a terraced house, you might not have this, or even if you're selling another business, it might be a very straightforward business, it might not require all this. But in my submission, it doesn't make any difference to the nature of the transaction, the nature of the payment, what the payment's for. If it's for disposing of the business, even if it's a very complicated disposal involving a lot of different work, that can make a difference. And then they say in 74, the next stage would to finalise the investment presentation, carry out a targeted marketing exercise, to follow a bit of due diligence with Deutsche Bank, assisting with the question and answer process. This would then lead hopefully to the final negotiations of one or two bidders and completion. Mr. McCord made the point that all such plans tend to be optimistic, and in the present case the process did not go into plan at all. Although they might have gone through most of the stages, there was a point when they seriously considered abandoning the sale process altogether because it looked as though the business might be sellable. They considered retaining the business and trying to turn it around, keeping it as a good business or selling it, etc. Again, I would say that is a natural part of any sales process. You might well, taking a more homely example, if you're selling your house, you might find that you're having difficulty selling it. You might speak to the estate agent and say, well, should we take it off the market or should we carry on? Should we lower the price?
And supposing...
That's surely all part of the sale process.
Yeah, and supposing they had gone down that line, I mean, you would submit the expenditure incurred for Deutsche Bank up till then would still have been capital expenditure.
If they decided to abandon the project?
Yes.
Yes, that would have been capital. After that, of course.
Then it would have been like Hamas. It would have been expenditure on a capital project which
aborted.
Materialized.
Yes, yeah, I think it would be the same. In fact, I don't know whether they'd be paid anything if it didn't happen.
Well, maybe they wouldn't.
But assuming they were.
Sorry, assuming it.
Yeah, assuming they were, my lord. Yes, it would be that would be capital. Yeah. But of course, then you'd be in a different situation because you'd then be deciding what you should do with the business. Yeah. So you'd no longer be in the sales, process. You'd be taking advice about how to run the business, perhaps, or how to improve the business, or whatever. So it would be cool. Or to shut it down, which then would be a different question again.
And that kind of general work on reviewing the portfolio of investments held by the company, and I think you accept that in principle probably would be revenue expenditure.
I agree. Yes. Yeah. Yes. So the process which led up to the strategic decision originally, there might well have been a lot of revenue expenditure. I don't know. There could have been a revenue expenditure there, and people deciding,
Well,
should we sell this business or should we sell another business? Or
one imagines in the big corporate group with lots of subsidiaries, there must be someone somewhere who will be carrying on a lot of
yes,
day-to-day oversight and keeping an eye on things and deciding strategically in what direction to go and what changes need to be made and all that kind of thing.
Yeah.
That, to me, has a classic revenue feel about it.
absolutely. Yes, no, I totally agree. What's different here is that they actually made a firm, very firm decision to sell, and they were going through a sales process.
But if you're right, I mean, that is the key point, is the decision in principle, which, as it happens, actually did lead to a completed transaction, albeit 2 years later.
Yes, yes. And then he says, paragraph 76, further document dated 31st July, headed Workstream and Call Agenda, set out the detailed steps which were envisaged to get as far as an agreed investor presentation. Deutsche Bank was involved in 3 main areas: structuring, investor presentation, and valuation. These work streams required a lot of man hours and a part of the heavy lifting Deutsche Bank was employed to do. This was the description that Centrica gave. This is why they engaged Deutsche Bank, because they didn't have the bandwidth, they said, to do all of this. So then we have further findings. I'm not going to go through and read all of them, but you want to read what actually happened. But none of, I would submit, the first thing you want to look at is what they were engaged to do and what they were paid for. But obviously you have to look at that in the light of what actually happened. But in my submission, what happened was what they were engaged for. And indeed, the First Tier Tribunal found that at paragraph 125. I haven't dealt with PwC yet, but they found throughout the periods linking these events, Deutsche Bank, PwC and De Brauw carried out their roles and did the work set out above, and the charges for it constituted a disputed expenditure. He also made the point that there were a lot more, there were some documents before the FTT, but there were far more documents that weren't there. There's a lot more work than might have seemed. So that's Deutsche Bank. PwC, we'll see at 95. The main service provided by PwC was the preparation of a report, the purpose of which was to assist a potential purchaser in due diligence with a view to buying the business. That is, they were preparing a vendor due diligence VDD report. The VDD report can be available to potential purchasers, and PwC will discuss the report with them. At a later stage, PwC might assume a duty of care to the prepared vendor. But the important thing about this was it wasn't provided to Centrica, this report, in the sense that it wasn't, obviously they did have it, sorry, physically they had it. It wasn't provided to them in the sense they couldn't rely on it.
But there was a finding that they used it for the purposes of...
Yeah, they may have used it, but it wasn't provided to them for that purpose. They weren't able to rely on it. Normally, if you get advice from someone on something, imagine you could rely on the advice. The point about this was, this was an unusual situation. It was being provided entirely for the PwC were providing it entirely for the vendor, so for the purchaser.
Well, this was so that PwC would then undertake a duty of care to the outside purchaser.
To the purchaser, yes.
Right, so you couldn't simultaneously have a duty of care to Centrica.
Yes, and they never had a duty of care to Centrica.
But that doesn't alter the fact that this particular advice was very helpful and useful.
Oh, yes.
It informed their decision-making as it went on.
Absolutely, but
that's, as you say, all within the umbrella or the ambit of the original decision in principle.
Of course, that plus the fact you have to look at what it was for, what the thing was for. The fact that they actually were able to use it indirectly in some way themselves doesn't change the nature of what it was for, particularly in circumstances where it wasn't, as I say, quite unusually. PwC specifically said that Centrica couldn't rely on it. Obviously, they can use it, but they can rely on it in the sense that they couldn't. If it was wrong, they couldn't sue PwC. Put it that way, they couldn't.
I mean, just harking back to the earlier discussion, I don't think this really helps. You are looking at purpose, aren't you? I mean, if you simply found PwC producing a due diligence report on the company, without looking further, you wouldn't know whether that was susceptible to your arguments or not. You might well think it was for the company rather than for the purchaser.
Well, you have to look at not the purpose in the sense of, going back to my subjective purpose, but you have to look at the objective circumstances. The objective circumstances was that it was being produced for the vendor and it wasn't being produced in a legal sense. I understand they had it and they were able to read it and make of it what they will, but it wasn't being produced to Centrica, for Centrica's purposes, as far as PwC. I think all of these point to the same thing, that
Yes.
it was part of the sales process. After all, you have to have, if you're selling a business, company with a business, you have to have a due diligence report for the purchaser, otherwise they're not going to buy it.
In fact, it was deliberately set up so that PwC would enter into a duty of care or undertake a duty of care to the preferred bidder. In a sense, makes your point that this was all absolutely aimed at a disposal.
Absolutely, yeah.
I see that, of course. But I thought the question we have to ask is, what is the payment for? In other words, the payment which is being claimed.
To PwC. This is payment to PwC.
Yeah, exactly. Yeah, what is the payment for? It might be said, the payment is for PwC's report. That's not for acquiring an identifiable asset or anything of that
Well,
sort.
the question is whether it's expenditure, whether it's for the disposal of the asset or it's on the disposal of the asset.
Yeah.
And we would say that something that you're paying for, which is actually probably essential for the disposal of the asset.
Yes.
Imagine, but certainly highly, it's
So
only
essential or...
It's probably essential to dispose of this kind of asset.
Or after that, you said highly something.
Sorry.
You said highly something. I misheard you.
Sorry, I said it was probably essential, but certainly, if not essential, certainly highly desirable.
Highly.
Yeah. But I think you'd probably say it was actually essential. I doubt you'd be able to sell a business like this without a due diligence report of this kind. But certainly, what it was clearly for was a sale. If it had been for Centrica, for their own purposes, deciding to investigate the business, then it would have been directed to Centrica, you would think. And so that, again, I would invite you to read 94 to 106, which are all the sort of findings about this. And then to grow, these were even more straightforwardly. You can see that.
I'm so sorry. Can I just go back to 103?
Yeah.
There's reference there to a deep dive report.
Yes.
The purpose of the report was to enable Centrica
That was a different.
to
Yes.
understand just how bad the problems were and to inform their decisions about the options available. Indeed, whether the problems were so bad that the business was unsellable.
Yes.
So,
But that report was directed to Centrica.
but are those part of the fees that we're talking about?
Yes, we were wondering whether there was there only seems to be one fee paid to PwC, as far as we can see. What I'm not sure about at the moment is whether they were paid extra for that, or whether they were just paid the amount that they already agreed to do the vendor. I would say that, in the context of what's happening here, that was still part of the sales process, because what they were considering was perhaps whether to withdraw from the sale or how they were going to structure the sale. So it was part of the process. Now, clearly, if they had decided to stop the process and then investigated further, I mean, actually terminate the whole process and then say, well, let's see if we can get the business of Oxio going. Then thereafter, what they would be doing, no doubt, would be may well be revenue expenditure. But all of this is in the context of this sale.
Supposing that this deep dive had been done before the decision to sell, that would have been revenue.
That would be different, yes, because that would be part of the process of, dealing with revenue, dealing with the business, and deciding whether to sell. They might have done the deep dive and then decided that this business is not going very well. We'll sell it. Now that's.
I mean, in theory, could there be a possibility of treating the deep dive separately from the rest of the PwC expenditure, on the footing that really its under true purpose was to enable Centrica Group to take a different look at the merits of going ahead at all?
Well, I would still submit.
Rather, as my daughter's put to you, had had it been done before July 2009, it would have been revenue expenditure. Possibly, we've been arguing saying that's still the case in relation to this bit, if we get to that point.
If you can identify a separate expenditure on that particular.
Well, if it's in, yes, I suppose even if we can't identify a particular period, we could say, well, the tribunal has to do an apportionment of some kind.
Yes. Well, I suppose you could say, well, originally PwC agreed to do the vendor report for the price that they agreed, and thereafter they changed the agreement so that they were doing the deep dive report and the vendor report. Yes. And if you wanted to, yes, but I still think there's difficulty because deciding whether to sell or not, or how to sell, is still part of the process of sale.
Yeah, I'm inclined to think the answer is to take a relatively broad business-like approach. Once you've made a decision in principle to sell, then be fairly tolerant as to what comes within that description.
Yes.
Including the possibility of whether one should abort the whole process.
Yes.
And this was helping to inform the decision as to whether they should abort the process or carry on perhaps in a different way.
Yes. Because the test, if there is the principle, is expressed at a reasonably high level of generality. I mean, expenditure on acquisition or on disposal. I would suggest that factually, if you find that the sales process began because they decided very firm decision to sell, and they engaged agents for that purpose, to sell the property, to be part of the process of sale, then that would all be, I would submit, expenditure on the disposal of the sale.
I mean, we'd only get to this if all sorts of other decisions had been made along the way, but just supposing that we had got to this. I see PwC charged £169,742. So it wasn't a sort of round lump sum. And going back to their engagement letter, they say fees will be charged in accordance with what's to be found in separate correspondence, which I don't suppose we have.
Maybe in the bundle.
But it may well be a matter of charging rates, in which case, theoretically, if you got to this point, you could try to work out how many hours have been spent by whoever on this report.
Yes, I should really have looked into this. But intuitively, you would feel that PwC would not be doing this without being paid for it, because it sounds like there's quite a lot of work involved in the deep dive report. So I think your Lordship may well be right, that you could probably identify what they charge for it. Finally, we have De Brouw. And we would say that when even I think the First Tier Tribunal decided that this was capital, although the Upper Tribunal decided it should be remitted. Strangely, given that this is a question of law, I'm not quite sure why they would remit the question, even if they thought that the First Tier Tribunal would.
But you haven't appealed against that part of it.
We have appealed against it. We appealed against all. The disputed expenditure is all of the expenditure.
But the decision to remit.
We've appealed against the decision that it's not capital, not all capital. So I suppose
it's not on your grounds of appeal. You have two grounds of appeal, neither of which refers to the Brouw specifically.
Doesn't refer to, well, it refers to the disputed expenditure specifically. All of it refers to the disputed expenditure. All of our grounds of appeal and the skeleton that for which you got permission, I think, it all refers to the capital D disputed capital E expenditure, which is all of the expenditure. So I think you're right. We haven't specifically appealed against the remitting to remit or mentioned it, but we have appealed against their decision that it's not all capital. So if you come to that conclusion, there'll be no use to remit. As I said, it's really strange to remit it anyway because it is a question of law. So the Upper Tribunal ought to be able to decide it themselves. Right. So anyway, De Brouw, you can see what this was in paragraph 108 and 109. And their fees were based on the actual time spent, it's 110. So normal legal charging. But it was all legal advice in relation to the sale, because obviously there would be issues about employment law and competition law and tax, etc. And we would say that's even more plainly capital. Okay. Can I then just quite briefly run through a few points, then I'll turn to expenses management. In fact, maybe the best way to do that actually is to look at the decisions and just deal with them and deal with the points then. If we turn to the First Tier Tribunal decision first, on this point, it's particularly, begins at paragraph 421. And at 421, the First Tier Tribunal makes a rather strange point that it doesn't seem that you could apply the principles in British Insulated and Staveley to an investment company. And the reason for that seems to be because in the actual cases, they were obviously dealing with a trading company, and they talked about the assets enduring for the benefit of a trade. It's the only reason I can possibly see why the First Tier Tribunal would come to the conclusion that these principles are not readily applicable to an investment company.
Sorry, I'm not in the right place.
421.
Is this bundle page 121?
It's page 100. Sorry, it's page 161, paragraph 421 of the First Tier Tribunal.
Sorry.
Yep.
Thank you. Yeah. Sorry, where are you now?
I'm just pointing out they started off by saying we don't think these principles that once and for all expenditure to create an asset of enduring benefit, etc., or to free a trade from an onerous asset is capital expenditure. They're not readily applicable to an investment company. They then say British Insulated was not in the business of setting up pension schemes. That was a one-off action of a capital nature. Staveley Co. was not a property company. But I don't really understand why that is not applicable. And then they go on to say over the page, taking the principles to the extreme, all investment companies' expenditures must be incidental to capital transactions, so their capital nature itself. Whilst I already submitted that's simply wrong. And then in 423, Mr. Mancord's evidence indicated that much of the sort of advisory work which is an issue in the present case could be and often was provided by the group functions, and the Centrica would buy and assistance of advisors like Deutsche Bank for various reasons, including the ability to do the heavy lifting where there was insufficient in-house capacity. There's no suggestion that the cost of the in-house team involved in Oxio transactions should be disallowed. Well, if they mean that the cost that they actually incurred would be disallowed, well, that may be because it was pretty minimal. But if they're suggesting that if the in-house team had done all the work that Deutsche did, that they wouldn't be disallowed, then I would disagree with that. And then they say, I've commented that investment management, especially in the context of a holding company or a trading group, involves not just a consideration of whether to buy or sell an asset, but how to buy it, sell or buy, or more pertinently, how to realise the maximum value from an investment, which is the case where we might not involve selling the investment at all. Considering the Regent Oil type of cases, the effect of the advice which Centrica obtained was not to bring about a disposal of the Oxio business, but to inform the management decisions about how best to do it. But we would say that's not the correct test to apply. It's also concentrating entirely on advice, which, as we've seen, much of what Deutsche Bank were doing, and indeed what PwC were doing in the vendor report, was not advice, but actually services, work that they were doing on the disposal. And then they say at 426, in the case of Deutsche Bank and PwC, at least, the payments were made for services, that is advice, and the advice was to be used to enable COHL to make decisions about its investment in Oxio. We would say that's simply a mischaracterization of the findings that they were already made as to what these advise these Deutsche Bank and PwC were actually doing in return for the fees that they're paying, expenditure. In the case of Deutsche Bank, that was strategic advice on the options of disposing of this difficult asset and assistance in finding a purchaser prepared to make an adequate offer for at least some of the Oxio business. In my view, the costs of such advice and assistance were part of the ongoing management expenses of COHL, as it enabled the company to make decisions about how it might realise value from its investments in Oxio. Now, this is where, in my submission, the First Tier Tribunal were muddling up the questions of management expenses, which are already decided. These were all expenses of management, right up until near the end, with the question of capital. The question of whether they were management expenses, we'd say, is a completely different question. And then TIB 427, PwC VDD report, in particular the deep dive, was advice which gave the management of COHL insight into the nature and extent of the problems of the Oxio business, formed the decision how to deal with that business. But what they mean by that is what they do with the business in the sale, as I said, in the sale process. The Deutsche Bank PwC advice used by CHL in conducting its investment business, it wasn't my view of a revenue nature. Again, we would say that's what it seemed to be doing, is muddling up the question of whether it's part of its investment business with whether it's capital or revenue. Of course, selling an asset is part of one's investment business. That doesn't begin to answer the question as to whether expenditure on it is capital or revenue. And then they looked at Dubrow. They said that was different in nature. It was directed not to enabling the company to conduct its business of managing investments, preparing to carry out a transaction once the nature of the transaction had been determined. So they decided that was capital. And they then go on to say in paragraphs 432 to 434 that a point is reached at which it moves from decision making to actual decision, and identify the cut-off point in 434 at the end, the point when Inico made the initial offer in January 2011 and COHL decided that it was an acceptable offer. The costs of Deutsche Bank and PwC up to this point were revenue, expenses and management deductible under 1219. And they decided that the work all done by Dubrow in 436 was all capital, because it was all basically at the end. But this just shows the incoherence of their position. How could it be right that there was a difference between after the point when an offer was made and accepted in principle, and before that? All the work was of the same nature before and after that. So that's the First Tier Tribunal. And then the Upper Tribunal. And I think we can take this quite shortly. We can look at the last few paragraphs of the decision on this point. Paragraph 127 of the Upper Tribunal decision. And they say, in our view, Parliament must have intended that some expenses of management would not be relieved when they were also capital in nature. On the basis of what was said in Sun Life and Camas, such expenditure is likely to be very limited in nature, and it may be that Parliament was acting out of an abundance of caution, and because HMRC had long considered that capital expenditure was excluded from relief under Section 1219. So we would say, first of all, it's difficult to can't see what there is in Sun Life and Camas, which suggests that legislation that was introduced after these decisions had been made was limited in nature, and that Parliament was acting out of an abundance of caution. They then go on to say the meaning of capital expenditure in the context of expenses of management is necessarily more limited than the meaning in the context of trading businesses. In our view, is aimed at expenses which do not normally recur, but which have the effect of creating, enhancing, or disposing of a capital investment. It does not exclude expenditure which informs decision making, exercising managerial discretion. But we would agree with that, but it's then the way they go on to apply it is strange in the next paragraph. In a case such as this, expenses of management are likely to be revenue expenses because the test is similar. But we'd say that's simply wrong. Secondly, the expenditure was not one-off in nature because COHL had many capital investments apart from Oxio Group, which might involve management from time to time, including appraising and acquisition, disposal, or restructuring. Well, if what they're saying is because there are a lot of transactions with capital, selling the capital assets, that would make it revenue, that's clearly wrong. We've seen a number of statements, so that's wrong. If they're simply saying, well, they might have to consider whether to sell other assets, we would say that's simply irrelevant. The point was, in this case, they had decided to sell it. That was the difference. It might be true that there might be management time spent on deciding whether to sell other assets. That's not what we have here. And they go on to say, and because Oxio Group would not necessarily be sold, again, we'd say that's completely irrelevant consideration. The fact that it might not be sold doesn't prevent it being capital. We consider the FTD was right to conclude that the Deutsche Bank and PwC expenses were not capital in nature. And then they go on to say, well, we think it's odd that they decided, that the FTD decided the De Broglie fees were capital in the light of all this. And they remitted it back to them to decide it on the basis of what they say in paragraph 134. Because they thought they had also informed decision making in relation to the disposal of Oxio, which one assumes that they did in a sense. I mean, you might say that, but that is simply the part of the process of selling. So we would say both tribunals heard the law in a number of respects. But of course, it is a question of law anyway for this court. So this court has to decide what are the relevant findings of fact. I would say that they're the findings that I've drawn your attention to, and on that basis, the correct conclusion in law is that these were expended on were expenses of a capital nature. Can I then turn to expenses of management? And I was going to take you just briefly to Sun Life and to Cannan's. If I can just say, the final conclusion that you would come to looking at CAMAS in the Court of Appeal is, the question is whether, is that expenditure after there is what they describe as a firm offer to sell or purchase is an expense of the sale or purchase and not an expense of management. But expenditure up to that time, they say, is an expense of management. And if we turn to Sun Life, now Sun Life was a very, a case about insurance company. It concerned brokerage fees and stamp duty. And each of the members of the House of Lords made a decision on different bases. But they came to the, well, apart from Lord Reid, they all came to the same conclusion, but their reasoning was not quite the same. If I could just summarise, perhaps, it might be easier. Viscount Simmons made a number of points, and can I just run through them? First of all, he said that the right to relief cannot depend on the way that the society chooses to treat the payments in its books. I think that's probably obvious. Secondly, they said the revenue's previous willingness to grant relief is irrelevant. To understand the revenue had a practice previously of allowing relief. It was also relevant that they had allowed relief for a large number of other items. Now, he then said, in the statute, commission means commission paid to an agent to obtain business for the society. The reason they said that was because the provision for expenses of management used to say expenses of management brackets, including commission. And the question was, what does it mean by that? And what it was understood to mean was commission paid to selling agents, not brokerage fees. He then said commission might be there to bring in something not otherwise included or make clear that otherwise might be endowed. He thought that phrase threw no light on the issue. he pointed out the original legislation, which was insurance company legislation in 1915. There were three heads: commission, expenses of management, and other payments. And he said that was significant in some way. And then he said brokerage and stamp duty are expenses specifically referable to and only incurred by reason of the purchase. Therefore, expenses of the purchase and not expenses of management. And he made the general points that the words expenses of management are words of qualification and limitation. It's not, so they limited the scope. It's not trading or general expenses which are deductible. And finally, he said management has its ordinary meaning, but doesn't mean running the company's business in a wide colloquial sense. So that was Viscount Simmons. Lord Morton expressed doubt as to whether brokerage fees in fact came within commission. He thought they might, but expressed no opinion because it had been agreed throughout that they didn't. He said the expenses were so closely linked with the transaction of purchase that they may naturally be considered as items of the total cost of a purchase, which had already resolved upon. And he agreed with Lord Somerville the words expenses of management should be given a wide construction for the reasons that he gave. Then Lord Reid, who partially dissented, he agreed that the stamp duty was not an expense of management, but he thought the brokerage was. What's slightly odd about this is that although Lord Reid seemed to be dissenting, it's his statement of principle, which is cited in the later cases, particularly Camas, as being the principle. But anyway, he said you could derive no assistance from the way that insurance companies are taxed or that trading companies are taxed. Not all expenses are included, but only expenses of management. The words including a commission were important, he thought. It must have been thought it was at least doubtful whether they were within the term expenses of management. It's reasonable to ask whether a payment should be regarded as part of the cost of acquisition on one hand, or something severable from the cost of acquisition, which can be regarded as expense of management. And I think that's the kind of phrase that was cited.
That's the sort of talisman test now.
The talisman test, yes.
And it was common ground in Camas on both sides. That was basically the test to be applied.
Yes. I suppose the issue is what's meant by cost of acquisition.
Well, that's
That's
one thing to state the test. That's another thing to apply.
Apply it, yes, exactly. And I have a terrible suspicion that Lord Reid meant something very narrow, but I'm not sure the rest of them did. Anyway, that's the test. I take it. But what he then said is that in dissenting, that you shouldn't distinguish between payments to commission agents, which is specifically covered, and brokerage to stockbrokers for selling. So he was relying on the words in brackets, including commission. And he said that brokerage shouldn't be distinguished from that, so therefore he thought the brokerage should be an expense of management. Lord Keith agreed with Viscount Simmons, and finally Lord Somerville considered the expression expenses of management, including commission, as clearly taken from the revenue account in the schedule to the Assurance Companies Act, which is the 1915 Act I was referring to. The fact that other payments in that schedule was qualified by the words accounts to be specified indicate that expenses of management, including commissions, was intended to cover all ordinary expenses. Then he said the words must be given a wide meaning. They cover both the management and carrying on of the business. And finally, these costs are a direct and necessary part of a normal method of purchase. The costs in question, and therefore not expenses of management. Now, what I'm going to now do is look at Camas. The reason I did it that way is because partly you can see from Camas what was said in Sun Life, because the important passages are quoted. But also, of course, Sun Life was on a very narrow point. And I think it's said in other cases it's an easy case in a way, because these were very closely related to the purchase, these items. But what they didn't necessarily tell you in Sun Life was how far it went. And that's where I think Camas comes in. The other problem with Sun Life, of course, is that, as I probably indicated, a number of the law laws relied on very, very deep archaeology of the provisions going back to 1915, and also on words that are no longer there. Because the words including commission were taken out, I understand, in 2004, at the same time as all these other changes we've been talking about. So in fact, in the Act we're looking at, these words don't appear. So it perhaps is not all that helpful to look at Sun Life, but Camas clearly is important. And Camas is the first authority in Volume 2. I think it's right to say that when you look at Mr. Justice Patton's judgment, he does take a very narrow view on what would not be an expensive management. He appears almost to be saying it's only things which are really directly part of the cost of acquisition. But that's not the approach that was taken by the Court of Appeal. So I'm going to take you to the Court of Appeal, and it begins at page 565, paragraph 31 at the bottom of page 565. On this issue, I agree respectfully with Mr. Justice Patton. It's a short point. If my analysis of the speeches in Sun Life is correct, the activities in this case were all part of the process of managerial decision-making. I see nothing in Sun Life or in the ordinary meaning of management which provides any support for Mr. Henderson's suggested distinction between the process of deciding on the sort of company to acquire and that of deciding on the acquisition of a particular company. I think it's important there to note that the argument seems to have been on the basis that this was the process of decision-making as to either what sort of company to acquire or on the acquisition of a particular company. On the facts of this case, unlike Sun Life, no final decision to purchase was ever made. By that, he meant the final decision in this case, in Camas, was the launching of a takeover bid, I think, which would have been the next stage in the process, which they would be preparing for by what they did previously in relation to the bargain group. I think that's the analysis.
Yes, and because it was a listed company, there was a whole lot of very closely prescribed procedure one had to go through.
Yes.
In order to set a formal bid in motion. And
yes.
The point was it never got to that point. They decided to pull back at the last minute.
Yes. Because once you set off the process,
then you're out of your hands.
I think
yes. Of a logic sense.
Yes. Yeah. And there could I think it's right to say there could be two different types of takeover, a hostile one or a friendly one. I think they were rather hoping that they could agree terms with Barden and there would be a friendly
That's right, but you had to prepare in advance for either eventuality, including having the appropriate documentation.
Yes, yeah.
So
yes.
That's one reason why it was also complicated and costly.
Yes, yeah, exactly. But they didn't reach that stage and then they stopped before it. The revenues argument might have been stronger if the stage had been reached of a firm intention to make an offer, triggering the strict timetable described by Mr. Reid. Even then, I would not necessarily conclude that any expenditure thereafter, even if the purchase proceeded, would have to be treated as cost of acquisition rather than management. Must depend on the circumstances. Between such a triggering event and a final purchase, there may be many chances and changes requiring what can probably be regarded as managerial consideration. How one should categorise particular expenditure in such case must depend on the particular facts. So he's not saying it all would be, but at least he's recognising that there would be expenditure after the formal process started. The takeover was launched, and that would be not managed expenses of management. Like the judge, I do not see this conclusion as involving any disagreement with the commissioners on their findings of fact. They held that on the evidence relating to acquisitions of this scale, the act of working up a potential offer is part of the decision-making process, and that in this case, the work was wholly directed at the projected acquisition. They saw these findings as leading to the conclusion that it was a direct and necessary part of the proposed acquisition in this case. This formula reflects the words of Lord Somerville in Sun Life. With respect to the commissioners, however, I think they misapplied the formula. Lord Somerville made clear that he regarded that expression as a very narrow one, not intended to be wider than the particular items in issue in that case. The fact that the work was part of the decision-making process supports its categorisation as managerial. That is not affected by the fact there is also a necessary prerequisite to acquisition and directed to that possibility. It was preparatory to the making of a decision to purchase, not part of the implementation of a purchase already decided upon. It's unnecessary to express a concluded view of whether the fact that no acquisition occurred is in itself determinative. One can imagine cases where, following a firm commitment to purchase, expenses incurred in carrying it out, but some wholly unexpected event requires it to be aborted. If at the time it is incurred, such expenditure is not an expense of management. It may be difficult to see why it should change its character thereafter. However, in this case, the lack of an actual purchase merely confirms the fact that there never was a firm decision to buy. Not really quite sure about the last sentence. It doesn't really seem to follow. But anyway, let's not worry. Of course, it's probably a bit wider than perhaps Lord Justice Calmworth anticipates, because if if they had triggered the strict timetable in the takeover, especially as a hostile takeover, there was every chance that it may not succeed. But it would still be part of presumably, some of the costs would be costs of the acquisition, which was then abortive. So I wonder whether it's quite as narrow as he suggests. But anyway, that's what we have here. So the question is really, how do you apply both the Lord Reid test as applied by the Court of Appeal in Camas? Have we reached the stage of a firm commitment to purchase in the present case? And as you have seen, both the First Tier Tribunal and the Upper Tribunal thought that we didn't reach that stage until the stage at which an offer was made by a particular purchaser and it was accepted in principle by Centrica. And we say on this that is too late. That's too late a time. That there's no difference in principle on the facts of this case between what happened after that and what happened after they had made the decision, we would say a firm decision, to sell in 2009.
On this issue, unlike the capital expenditure issue, do you accept that this is not a pure question of law, but rather we would have to, well, somebody has to find that the First Tier Tribunal has erred in its approach or reached a conclusion which was not available on the evidence?
Yes, but we would say, what I'm pointing to is, what is the test?
Yes.
And I would say that if I'm right, that they misapplied it, then that would be an error of law.
Right.
They can't simply find as a fact that there was a firm decision within the test in Camas. That's a question of law, what that is. Of course, what findings they make about the firmness of the decision and what the parties have done would, of course, be a question of fact. I'm very near the end, my lord, but I know you have to rise now. I mean, I wouldn't spend very long in the morning, so I imagine...
That's what I was just thinking about. I'm afraid I would like to stick to 3:45.
Yeah, that's fine.
Are you comfortable between you that 4 o'clock tomorrow will still be all right? We could start at 10:15 if that were necessary. I'm not encouraging you to think that necessary, but if it's needed, then let's do it.
Well, if my learned friend feels it's necessary, I would be happy to start at 10:15. I would probably just fill up the time between that and 10:30. So I imagine.
Let me try fairly pinning you down. In the morning, how long do you think you might be?
Me?
Yes.
Oh yeah, I imagine no more than 15, 20 minutes at the most. I'm basically at the end.
Mr. Rivet.
My lord, if learned friend is finished by 11:15, I would think that 10:30 would be perfectly adequate. Thank you very much.
In which case we'll stick to 10:30, but we'll rise now.